I'll wait till the third, huh?
I mean, that's between the mother and the baby, as far as I'm concerned. You never know.
He said they were looking at the third.
Yeah,
He took off half a day today, Judge, something like 2 weeks.
yeah,
Hope everything's all right.
yep.
Well, welcome everybody. Welcome to the negotiations for January 30th for the Robertson Fire Protection District. We are here to negotiate a new contract for the either 2024 or 2025. Whenever we get finished, let's go ahead and get started with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Great, Director Seavey, you want to go ahead and do a roll call?
Director Seavey, here. Director Field,
Here.
Director Guyton,
Here. All right, well, we have a couple new faces. Let's just, since we have the public here today, let's go through it one more time and introduce ourselves. If you guys want to introduce yourselves.
Sure, my name is Chris Mancy. I'm with Local 2665 as the 2nd District Vice President.
I'm Steve Fisher. I'm the Robertson shop steward.
Aaron Brandon, I'm the A cruise ship rep.
And I'm Duffy, John Duffy, with 2665.
Jennifer Guyton, Director.
Ivan Schrader, negotiator for the district.
Adam Long, assistant fire chief.
Steve Field, Director of Treasury.
Maggie Seavey, Director and Secretary.
All right, and since we have our new district negotiator, I'll go ahead and let you get started with how you want to start off.
I've had a chance to review paperwork that exists currently. And I've had some brief conversations with the directors in terms of recent history for purpose of negotiations. Problem I have is I've not heard from any of you and you haven't heard from me. And what I'd like to do tonight, in order to bring me up to speed so that in responding to things that you asked about or we're talking about, I know where you're coming from. And so I would ask if you would to walk me through the agreement and let me know where you have TAs adopted so that I know that those are off the table. I did not find any, and I understand there have been discussions, but I thought, well, maybe you have TAs that didn't get distributed back to the board. And so I guess the first question I have is under the the rules that govern these negotiations, it was indicated that, not indicated, stated that tentative agreements would be signed off by the parties as they were adopted. Kind of gets them off the table, windows down, that size of the document to where we're now dealing with only those things that are in contention. We've gotten things we've agreed to off the table. And so I thought, at least for my benefit, to get that background would be very helpful. I've looked at a number of things, like I say, in the current agreement, but I don't know for sure what's been TA'd and what's not been. So if you can enlighten me to that aspect, that would be great.
Yeah. So first off, under that, those rules there, it never mentioned a written TA. It just says they will have the ability to TA our groups. So we, as our group and as the board and their group, along with a lawyer, last time we pretty much met, we had come down to just one final thing. Everything else had been agreed upon. That final thing was the duration clause. We proposed one. The board did not like that one and had some issues with it. We spent pretty much about an hour on that one clause, that one article. At the end of that, the board said they were good with that. Their lawyer was here. He said he was good with that. And we ended the meeting with the board saying that their lawyer was going to go ahead and write up a resolution that would basically put a bow on all this, put everything together. We broke at that point. He went ahead, wrote that up. We had some issues with the resolution, which we talked with him about. He corrected one of those issues. At that point, we said we were good with it. He said he was good with it. He had no problems. Then another approximately 10 days goes by. Now, all of a sudden, he disagrees with that last statement, says he has issues, and he's recommending that the board does not sign it. In our eyes, the board said they were okay with that agreement. So quite frankly, we're not sure what we're here to negotiate anymore. And in addition to that, I would have to say I object to the fact that there is now another lawyer in here. Every time we turn around, it's this lawyer or that lawyer, then all of a sudden there's another lawyer. That goes against bargaining. The groups that make the rules and say that we're good with them are supposed to be in the room. That's why they had a lawyer sitting over there. We were fine without having our lawyer in here. We agreed to it. They agreed to it. That's where we left it. And that's where we're at now.
Perfect. Well, do you have a copy of the rules with you?
Yeah.
I'd ask you to take a look at paragraph 6 of those rules, where it says both parties will diligently through proposals in a professional business-like manner and shall initial each section or article of the proposal, including any handwritten elements, edits, whenever a tentative agreement has been reached on verbiage of said article at the time of agreement. What that says is the agreements have to be in writing and they have to be TA'd. So if we don't have TAs, I have a problem in terms of accepting any representations that are being made without some explanation from you.
Well,
Now let me finish.
oh, sorry.
Secondly, bargaining committees are able to bring people as they see it appropriate. This session or these sessions have been an interesting change because most negotiations are conducted in a closed fashion. But there's an interest in the district to having the constituencies of the district understand what's going on. And so the district has agreed to conducting its negotiations in open session, which are, my understanding, are being recorded, so that if anybody has a misunderstanding in terms of what's been signed, what's been said, we have the ability to go back and get that. And quite frankly, that avoids a lot of problems in the future where somebody says, well, my notes say this, or your notes say that. We obviously don't have the same notes because we were different people taking different notes, and we heard things potentially different. That's why it's important for me to understand what it is you believe you had TA, because that's what the ground rules call for. So if you're telling me you have no TAs, that's a problem for me to relate to if I decide I want to advise the board as to issues that they might want to revisit for discussion purposes. At this point, I don't have any recommendations to the board because I've not heard your positions, and not having heard your positions, I don't know what it is you're intending to do. I will tell you that my experience has been that it's important that the parties understand each team's position, because when it comes down to writing, it's really important that the writing conforms to the intent of the parties. And as with any contract, you want to avoid future problems by having that contract be crystal clear, if you can avoid it. And so those kinds of records are really important for purposes of putting that paper together. It may sound like a little tedious to do that, but negotiations are for the betterment of everyone, firefighters, as well as the voters of this district who are represented by the board of directors. With respect to what is agreed or not agreed, there is a specific law that says no contract is effective in Missouri unless it has been adopted by the governing body of the entity with whom a contract is suggested. the statutory number on that is section 432.070. You appear to have identified some of that because you've been dealing with expired contracts and making them extended for shorter periods of time in order to arrive at some new destination. And as I understand it, and I looked at some minutes where this agreement is actually good through June. So it's not like we're looking backward and trying to undo or overdo items. What we're trying to do is to be prepared by June to for the board to hopefully take action, or as your proposal, not your proposal, as the ground rules were identified, to go to mediation with a third-party neutral who will help possibly bring the sides together. So that's the reason for asking for the information from you directly. The board members are very helpful in what they understand, but having you tell me is a way better position than having them interpret for me what it is you said. So that's why I framed the question I did. The next issue deals with who the district decides to have at the table or not have at the table. And that is a decision that the board makes for its side, and it's a decision that you make at your side. And based on what I heard today in the introductions, you've had some change in your board committee along the way as well. I will tell you that my position here is to serve as a spokesperson and to caucus with the board and to provide them with advice, but to carry out their direction. And so, you know, as we move through the process, when I serve as the spokesperson, I don't make the decisions, it's the board. But I will tell you that if the board makes a commitment and TAs it as a professional in this area, I will say to the board at open meeting where a contract has been arrived at, this document should be adopted because you've agreed to all the proposals, but for the fact of an official vote. That's how the business works. So the team makeup is as it is. The law is what we are required to do, and that's hopefully what we will be able to accomplish. Now, if it's a problem for you to go through the document tonight, and it might be, then what I would ask you to do is to provide a written document going through section by section, identifying what's been agreed to and TA'd, so that I can work from that document, and the board will then have your position as to each of those items. It'll put me in a position to sit with the board and say, okay, did you agree to this? And was it TA'd? Or did you not agree with it? And the board's going to tell me. And from that, then I'll be able to give them advice from which they can then make decisions. So it's a multi-tiered process. You do the same thing with your bargaining committee. Your group here makes some preliminary decisions, but both parties realize it's got to go back someplace else to be adopted. You would have to go back to your membership, the bigger group than what we have to deal with here. But nonetheless, it's a requirement, and the rules call for that as well. And that's a good deal. I don't want to have a client adopt an agreement where the union membership says, not us. And so that's why you all usually take the process back first, get the approvals, and then it gets on the board agenda for their determination. You know, I will not suggest a contract be adopted if I believe that the agreement has not been reached. That will be my public recommendation because the board takes action in a public meeting. What they do with the recommendation is neither here nor there because that's their job. So, so as to the committee, as to the law, as to where we are, that I think covers everything. But official action, and the board has rejected, as I understand it, rejected the document that was presented along with some draft resolution. And so where we are is we have a document that's still in flux, that has not been adopted, and needs to have that kind of review so we can get to where we need to go. it seems to me that, if that facilitates, where we are tonight, because of my late arrival to the committee, I'm asking for your courtesy to provide us what you think has happened, in writing, so that we, actually have the ability to reflect on what it is you've asked for in light of the language that's in whatever you tell us you think has been agreed to. So that brings us to, I'd be happy to answer any questions along those lines.
Yeah, so you want to know from us what we said and why we think that way with the articles coming in the CBA, correct?
No, it's not correct.
What?
I want you to tell me what you have TA'd and what the article and sections are. So by way of example,
Well, I can stop you there. I answered that in my opening statement. We verbally TA'd this agreement.
you know, you didn't tell me that you didn't say you TA'd it, period.
Well, if everyone says we're good with that, we're gonna write a resolution and we're gonna sign this, that's a TA.
Well,
So,
I understand your position is, that we don't agree with it.
I mean, obviously, I guess we wouldn't be sitting here. But I mean, for me to go through and tell you what we verbally TA'd, I would be just handing you the document that I'm sure you already have.
Well, that's,
Hold on, may I? So are you speaking of this document right here?
No.
Okay, well, just to clarify for the public, TA means tentative agreement. And as far as, what had happened, there was no agreement at the ending of the last negotiations as far as the actual language for the duration of agreement. That was discussed back and forth within emails. It was not done publicly. So when we ended, we did not have a TA on anything. Thank you, sorry.
so that's, I'm not looking for you to rewrite anything. What I'm looking for you to do is go through the articles section by section, part by part, and say, this is what we agreed to. So that I know that's what your feeling is.
Okay.
Now, if you want to give an explanation as to why that works, I'd be more than happy to do that, but at least that puts me in a position to know what you think is left open. Said at the beginning was, we think we only got one piece. And when I asked you about the TAs, your answer was, no, we didn't TA. Then I asked you about the rules, the rules that were agreed to, that call for it to be in writing, and it's not in writing. So I guess the next question I have is, do these operating rules that were agreed to still apply? I certainly hope they do. I looked at them and, you know, in my experience, these are actually not bad rules. A couple things I don't like, but I certainly would, you know, I'm not gonna argue with it. It's been adopted. But having said that, I'm one that follows the rules. And so in order to have those rules properly allocated, then I'm gonna need to have that information. If I don't get that information, it's gonna be next to impossible to advise the board. And, you know, we'll have to see where that goes. The next piece, I mean, that answers those questions. The next piece, under the rules, if we were to exchange, provide new proposals, rewrite, amend, etc., there's a requirement that a proposal be given 7 days in advance. We received a document in advance of or on the 7th day, which meets that qualification. And it's called the duration of agreement. And I think you had that up on the screen.
Yeah, let me get that up.
And I'm unfortunately unable to share my screen with those at home. So I'll go ahead and just read it for the public at home, if you're okay with that.
Yeah, this is their proposal. It's not an agreement. It's a proposal.
This was proposed verbiage on January, for the January 30th, 2024 negotiation meeting, which is this meeting. Duration of agreement, the agreement shall not terminate in the event one or both of the parties assert the position the other has acted in bad faith during negotiations. Instead, the party asserting bad faith shall proceed to circuit court to seek a declaration that the other has acted in bad faith. During the pendency of the matter before the circuit court, this agreement shall remain in full force and effect. If the court should determine neither party has acted in bad faith, the parties shall resume negotiations under the supervision of a special master appointed by the court or agreed to by both parties. During the pendency of resumed negotiations, the special master shall have the sole discretion to declare an impasse.
Thank you. So we are preparing a response to that, but I will give you a verbal response. First off, that language is not acceptable as proposed. Primarily, it's not acceptable because the language guarantees that the labor organization has the veto power over the district in terms of the district board making decisions. If it should adopt the language that you provided, the board would be agreeing to having a veto allowed by the bargaining unit over the changes to a contract. Secondly, negotiations don't belong in the circuit court, although you have a provision or you have a lawsuit, I guess, out there somewhere, that don't need to be addressed by the court because the court's not a member of this district and is not a member of the union. So the best place for those issues to be dealt with are the people who are going to live with it after it's done. So going to the circuit court is not acceptable. The question of bad faith is a term of art. And bad faith is subject to a whole range of interpretations. When you say, in the event one or both parties assert bad faith, all that means is you made a complaint. And once you make a complaint, that's an assertion. And an assertion may not be based in fact. So now you're going to send it to court to delay what's going on. If we accepted this with the language that it stays in force and effect, we already know how long that lawsuit's been pending around, assuming that's the one you would use. If you file a new one, we're talking about an extended period of time that's going to interfere with the district and the bargaining unit going forward. So it's not acceptable in that process either. If nobody is acting in bad faith, the court sends us back to the table. Well, we're already here. Why would we go to the court to have them tell us that we need to come back to the table? That doesn't make sense. All that does is buy time. That's to nobody's advantage. It's certainly not to the district, and we wouldn't think that the employees of the district would like to have delays simply because the court's in session. Next, it says that the court shall appoint a special master. Well, you already got a rule in place in the document dealing with the processes that call for an impartial mediator that the parties select. And it's in paragraph 8 of the signed agreement that says, and I'm going to paraphrase it, if the process doesn't work in negotiations, then the parties will agree to go to a neutral service and secure a mediator to facilitate the negotiations. And then it goes on to say, well, if that doesn't work, then we got to go back to court. Now, that may or may not be the best place to be, but that's what the rules call for. So we've got time to negotiate. We have a requirement for a mediator that the parties have to agree to before you can go anywhere. And this is a document that everybody's agreed to. So your proposal violates the language of the ground rules that you provided or that the parties agreed to. And so then what happens if there's an impasse? Well, an impasse, again, is a very technical term. It means the parties can't reach agreement. And if they can't reach agreement, the district is in a position to exercise its authority to implement what's good for the taxpayers and the residents of the district. It's an activity that an employer rarely likes to implement. But when you identify that it is the sole discretion to declare an impasse, this third party out there that we don't even know who it is, that you've now tried to change, frees us up completely to go about our own business and do what we wish, when we wish, without moving farther negotiations. In my mind, and I think in the board's mind, if we can't resolve it at the table, then we need to come to an impasse on our own, where the parties agree that we've reached that, We've gone through the mediation process, and then we look to see where we go from there. And up to now, the board has been willing to expand the term of the agreement for a short period of time to get to the end. And it seems to me that that is a methodology that fits within the framework of the rules that were adopted, but it also gets us to an end. So that's our response to the proposal you gave us. Secondly, I think the board has made it fairly clear that they're not going to put a veto provision in any contract for collective bargaining. It's just not going to happen. And as their advisor and negotiator, I could never recommend that they put that provision in it, simply because it leaves one party to control when the statutory responsibility for running this district is with the board. It has an obligation to deal with its employees fairly and openly in good faith, but its obligation is to the voters and taxpayers of the district first. And the board will not, at least as I've learned from them, are unwilling to sacrifice the district board's responsibility to the taxpayers and to the voters of this and residents of this district. So we will have language to provide in the appropriate time to meet the 7-day requirements. You'll have a chance to review it, but it'll be significantly shorter. It will have a beginning and an end. It will have an opportunity for extended term if parties are making success in the negotiating process and are close but not going to get there. So we don't have to face going to a board meeting when the board says we're not going to adopt it. Constitution is very clear, and in fact, your attorney has been very helpful in reminding me that the language of the case, the lead case from the Missouri Supreme Court says, once the negotiations are completed, the elected body has the right to accept, to reject, and to modify on its own. And so the board has exercised what the Constitution and the Supreme Court of Missouri has said is their prerogative in carrying forward. And the reason for that is the Supreme Court will not and has not taken away the ability of the district elected board to carry out its duties and responsibilities. And it gave them those options. And that's where the board stands right now. So we don't have an agreement. We have an agreement that's good through June. So we've got time. This is only the end of March. The rules call for at least one meeting every 30 days, give or take. We certainly can arrange to do that. So I would ask that if you have a document that you want us to see, that you get it to us as quickly as you can, knowing that the 7 days comes into play. To the extent that we have a response to this duration of agreement, we certainly will have it for you in advance of the 7 days, so you'll have a chance to review it. So that's kind of where we're at the moment. I'd be happy to answer any questions that you might have to advance the progress.
No, we don't have any. We've already argued for over an hour on this article with the board and the I guess former now attorney to come to an agreement. So obviously, I mean, what we agreed on as a group has been cast aside. So I guess that's pretty much my main problem is now that we've already spent so much time learning on each side's where we wanted to go. Now we have another person that comes in who has their own thoughts on the process, what's acceptable and what's not acceptable, which is just going to create a longer term for us to be in here negotiating.
I want to correct what you think you heard. I didn't ask for the documents and that response to make up my mind whether it's good or bad. I asked for those documents so that I know what's on your mind and what you think you got. I can't envision that without seeing it. So actually what I'm asking you to do is enlighten.
Yeah.
And sharing those facts will help in my response or directing the board, but I don't have an opinion yet.
Okay.
To the document. I don't even know what the arguments were because I didn't sit in those meetings.
Mhm.
So what I'm asking you to do is to provide me with information from which I can then advise the board. And it may be that I will advise the board, possibility, that, you know, what they've done, and we'll worry about what you claim is the one section. But I need to see those TAs, so I know what was agreed to. And if there's a special explanation, you can provide that if you think if I might need guidance, that the words don't say what they say.
Okay. Yeah, well, I mean, we can, definitely provide that.
Perfect.
Director Stevens, want to say something?
I was just gonna say, I'm just a little confused. Because, the agreement that Mr. Duffy is talking about was on the table to extend the current CBA that ends on June 30th, to December 31st, 2024. And quite honestly, I thought we were coming to the table to continue, because I thought that was gone now, and that we were coming to the table to go ahead forward with
Just
the
a new 2024,
the
2025
new
CBA.
contract, because
Well,
we couldn't come to an agreement about that duration.
that may be the short answer.
I was just wondering, I was
Yeah.
confused.
Now, all I'm doing is asking for information.
Sure,
We've not made any decisions in terms of where we go.
sure.
If June comes and goes and we don't have an agreement.
I was only saying, because I would understand what Mr. Duffy's talking about with the TA stuff, because if we're talking about the last agreement that we agreed to extend forward to December 31st, I would at least agree that most of the things in that contract because we agreed to extend the entirety of the contract, except that duration of agreement, right? Because that was gonna have to change to say December 31st.
Well, there are some things that we can talk about in caucus.
Yeah, but a new contract, I don't know that we TA'd anything.
Well, that's why I've asked the union to provide me with their information, because I don't have it. So that's going to be very helpful in terms of where we are and how we proceed. So your concern is correct. And what I'm trying to do is find out where
Find
their
out what they
problem
think,
is, so that I can take that into consideration when I address advising the board.
Yes,
And it may be when we get their report that, you know, the board's gonna say, oh, well, yeah, we're good with that. And if you do, then, and it goes the way that's been represented, the only thing that's left is the duration. They'll have our piece of the duration. The next meeting, before the next meeting, it's at least 7 days in advance of the next meeting. So it's not like we're holding anything out. It's just, we're looking for information. I'm looking for information. I've already gotten some input from the board. But the negotiations are a two-way street. And you can't listen to just one side. You've got to listen to both sides. And so this is my opportunity and your opportunity to share your view. And that's all I'm asking you to do.
Sure, we're happy to do that. I think you can appreciate some of the confusion and maybe the frustration that there's been a couple of lawyers in here with different parameters, ground rules. I guess we thought that maybe you would have been apprised of what that looked like as you stepped into it. So I think we're just trying to sort through what this is going to look like moving forward.
Well, and once I see what it is you believe has been completed in a written format, that it may just move forward with one section. I don't know. I don't have your side of the picture. And until it's kind of like like I use this example with my grandkids. You know, we buy them a picture that's got all the figures on it, no color. And the kids decide what color they're going to make that picture. So when it's done, we put it on the wall and be proud of what it is we've done. The collective bargaining system is a lot like that. We come to the table with our own views. We have a picture where we want to go. We add the color, and when it's finished, it gets posted for the public and the world to see. And that's where we're going. So it's a kind of a mixed parallel, but it gives you the idea of what we're looking to do. That's it.
Okay.
Anything else you'd like to ask?
No, not at this time. I mean, I guess it sounds like you're going to basically start this process from the beginning, possibly. I mean, if you're looking at every single article.
I asked you to provide me your position on the article. I didn't say that we were going to change it.
I didn't, well, excuse me if I misspoke. I'm not saying that you said we are. I said that that's the possibility that we may just end up starting this whole process over from the very beginning.
Well,
I would, sorry,
That's not the case.
Oh.
I would anticipate that there are pieces of that document that are not gonna, that are gonna be fine. And we're gonna move forward with those and get them TA'd, get them off the table. It is possible, probable, that there might be, some changes that will be requested, once we see what your positions are. So the possibility of starting from scratch is zero. The possibility of some changes is yes, there will be changes if for no other reason than the duration agreement, which is not acceptable, period. And I gave you the reasons for that. So, you know, be happy to answer any other questions.
No further questions from me at this time.
I have one, issue that I'd like. I understand that you're represented by counsel. Is that correct? You have an attorney that represents you or not?
I mean, yeah, you know, Rick.
Well, that's what I want to find out, because without Rick's approval, I can't communicate directly to you all. I have to go through Rick, but he has to come through me. If that's waived by the union, that's not a problem. But I don't want to be stepping on Rick's toes, and I also don't want to be in a position of violating my responsibilities where there is an attorney. If his representation is limited, I need to know that. Rick can tell me that.
That's fine. That should not be an issue.
I don't think so. I mean, Rick and I go back a lot of years.
Do you mean inside the room or additionally outside the room
You know, I need to know where Rick's position is.
for you communicating to us?
Yes.
Okay. Anything else?
That's it for us.
well, let's go ahead and set our dates for the next negotiations. One backup date as well.
You know, given the fact that we're gonna get some paper for you, probably gonna look closer to the end of February, to stay within the 30 days, but also within the calendar month. Things that each should track.
What about, February 22nd? And then February 29th as a backup? Does that sound okay, or is that too soon, the 22nd?
The
I
question
think
is,
that's 14 days. That would be enough time for 7 and 7.
right, no, that, the 22nd and the 29th work. That depends on your guys' schedule.
22nd, 29th, that's fine with us for primary, secondary.
We'll do the primary on the 22nd and then the backup on the 29th. 6 p.m.
One second.
Directors, well, good, okay.
I'm good.
That works for me.
When do I get back to 20th? Yeah, I'm good.
Oh, yeah, we're good, yeah.
Okay, we were just
Sorry,
waiting on
we're good at
6
6.
p.m. Okay.
And
I was counting days, sorry.
To be clear, and distributions on that 7-day rule is 15.
Yes, yes. That's what I was
January
counting.
15th. February. All right. Let's go ahead. Can I get a motion to close this special open meeting for January 30th, 2024 at 6:41 p.m.?
Motion.
I'll second.
All right, Director Seavey. Aye. Director Field.
I.
Director Guyton. Aye. I have it. Motion passes. We are adjourned. Thank you.